time now for another In the Legal Know with Vincent J. Russo. And today, Vincent is focusing on a type of real property ownership called the life estate. He'll be doing a 3-part series on this. And I had to admit, I've never heard of this before, Vincent.
And that's why we're going to do it.
Thank you.
So I thought about this. It is a simple concept, but it is complicated. And so I thought, break it down into 3 parts. So today we're going to talk about the pros and cons of a life estate. Next Monday, I'll come back and we'll talk about the tax consequences. And then the 3rd part will cover Medicaid and life estates.
Okay, we're going to start with the basic right now. What is a life estate?
Okay. It is an interest that a person has, a life interest in real property, your home, to use, occupy, and possess. So someone has the right to live in their home. They can do what they want with it. They can possess it. They can occupy it. And that is the simple definition of a life estate.
Okay. So how does life estate work?
Okay.
Yeah.
So let's have an example. Mom wants to transfer her home to her son when she passes. But she would like the certainty of it. So she does it now. She transfers her home, but retains the right to live there. And so that's the life estate interest. So when she passes, the son now owns the home without probate. And there's a tax benefit. We talked about step up in basis some time ago. And that's where the value of the home for tax purposes is the fair market value when mom passes away, the grantor. And when the son goes to sell the home, it saves capital gains taxes. Okay. So avoidance of probate and also the benefit of saving taxes when it's later sold.
Okay, somebody out there said, oh, that sounds like a good idea. Yeah. How do I create a life estate?
All right, so typically it's done in a deed. So the owner of the property is the grantor. They sign the deed. They give the property to the grantee. The grantee signs the deed. In the deed description, it says that the grantor is going to retain the right to live there, use, occupy, and possess. And then that deed is recorded in the county clerk's office. So it's a pretty straightforward process. You can give a life estate to a third party. So the owner could be mom, and she could say, I want my daughter to have the right to live there for her lifetime. And then it passes to my 3 children, for example. Now we're getting a little more complicated. All right, so the deed is typical. You can do it in a trust, but that's not often used.
Okay, so obviously there's benefits to this.
Right.
What are they?
Okay, so the major benefit is the avoidance of probate while retaining the right to live in the home. So the avoidance of probate means that it simplifies your estate planning process. You don't have to file a will. You don't have to hire the attorney to probate that will in the surrogates court here in New York, for example. So the ownership passes automatically. In my example, when mom passes, the owner automatically becomes the son without any additional legal work required.
I'm guessing that the benefit peace of mind.
Right.
For the mom.
That's right.
You know.
That's right. She knows that her plan is going to be implemented.
Okay. Any potential problems?
Then we get to the cons, right? Okay, it's loss of total control, and that's the big one. So, mom, in my example, transferred the home to the son. It's split ownership. The son actually owns the property subject to mom's right to live there. So she's lost total control. If she wants to sell the house, she needs the son's approval. She wants to refinance the house, lease the house. All right, so that's level 1, a concern. Loss of total control. Now, let's say mom wants to sell the house and the son says, okay, mom, let's do that. Mom does not get all the money at the closing. Some of the money goes to the son because they own it together.
Oh, wow.
Mom may not be happy with that. And then what happens if the son has creditor problems? Liens can be put on the house. While it's mom's house, and all of a sudden creditors are coming in.
That could be, to me, that sounds like the biggest potential problem you could have, right?
Well, no, one more.
There's more?
One more. One more. Mom wakes up and says, I want the house back. Or I don't want my son to get the house. I want it to go to my son and daughter. She needs the son's approval to change the beneficiary or to return the house to mom. Now, there are some legal ways of working through that concern. It gets more complicated. So the key here is if you want to simplify your estate plan, you still should see a lawyer, meet with a lawyer, understand this concept, weigh the pros and cons. The attorney will be able to help figure that out before you go ahead on your own. The other thing people do real quick is that some people will just transfer the deed directly to the son and not retain a life estate. And that could be very costly from a tax standpoint, and also if mom wants to live there.
Okay, so this is just the beginning.
Yes.
Vincent, thank you. This is the introduction to life estate. Next Monday, we'll have part 2 in the series, which we'll be looking at
Taxes.
Of course. Well, you always have to talk about taxes.
It's tax season.
Of course, we can't wait.
Right.
So thank you. It's very interesting. It is something at least brand new for me. So thanks, Vincent.
My pleasure.